Good afternoon, I'm your host Brian Buckmeyer here at the Law&Crime Trial Network. Now we have a live trial here out of Florida where we have two defendants, Garcia and Magbangwa, who are charged with the killing of an FSU law professor. Let's take a look at some of the live testimony we have today. So while that witness is taking a step down and we're waiting to see who's going to take the stand next, I want us to welcome our law crime analyst, Ecleynne Mercy. How you doing today, Ecleynne?
Hi, how are you?
Oh, I'm great. So we've got another great one here for the audience. It seems to be quite entangled, this whole murdering of a law professor, connection through the dentist and the boyfriend and the girlfriend and the mother, there's a lot of moving pieces here. It seems kind of difficult to prove, though, unless you got all the evidence.
Yeah, and that's what, the statute of limitations on murder is, there is none. So I feel like with these types of cases that they just jump the gun. Just investigate more, figure some things out before you just put it out there. And we have no idea how do they connect to this professor? I don't understand. I don't understand what type of case the state is trying to put on. I'm lost.
Yeah, this is definitely a case where I think there's going to be some graphs, some diagrams, some strings connecting one person to another. But one person that's very important is a co-defendant who's already pled guilty, Mr. Rivera. He took the stand and testified, helping to connect some of the dots. Let's take a listen to some of his testimony. I mean, I've never seen a better star witness. Ecleynne, this person, Rivera, is giving them the whole farmhouse and then some. I mean, what else can Mr. Garcia say?
And then he gets like the deal of the lifetime. So, I mean, you have to you really have to balance it with the type of deal that he's getting. It's my understanding, 19 years or something like that. So he actually participated in the murder, is there. He's a snitch. I really can't put that much credence to what he's saying because he got a good deal on with this case.
I guess the question would be, when it comes to cases like this, corroboration. Because if he's snitching, as you're saying, yeah, we can't really trust him, because the question becomes, why didn't you say this before the deal was on the table? If this is you kind of alleviating your soul or trying to do what's right, you would have done this before the deal got there. So why can't we trust you? But if the evidence corroborates what he's saying, does that spell trouble for Garcia?
Yeah, but still, it makes no sense, though. Like, I understand that, okay, if for Garcia, I get it. Okay, he's saying that Garcia did it. However, how? Why? Why is Garcia shooting a man in a Prius? Like, why are we there? We don't know. They have not connected all the pieces. We know Garcia is not going anywhere. You want to figure out who all is involved. Why is this man no longer being a professor at FSU? Give me that, state. Figure it out before you put a case up.
Yeah, it definitely seems like they're putting the cart before the horse, especially when it comes to the family who they believe started this all. Now, live in court, we have the lawyers making some legal arguments based on the fact that evidence was not turned over prior to the court call and prior to being testified on the stand. Let's take a listen to what those arguments are. All right, so it's a little hard to make out, a little harder to understand. What's going on basically is the defense is saying that the witness had testified to information that was not given to him. Now, as a public defender, that is a big deal. It's what we call prosecution by ambush. It's what a lot of DA's offices do around the country, but a lot of them are reforming to give all of the incriminating information prior to the court case. So at least you can have what's called an effective assistance to counsel rather than an ineffective assistance to counsel, which is a constitutional violation. Ecleynne Mercy, when I heard the words from the prosecutor, well, I didn't find it to be that sufficient, I cringed. I hate those words. It's not for them to say that. It's for the judge or the defense attorney to say that.
Oh, my spirit. Again, I cannot when they do that. So the state has an obligation to turn over all evidence, especially exculpatory evidence. Or if they don't, it's a Brady violation, which means that, there's evidence out there that can potentially help, prove that my client didn't do it. And in this case, if there's evidence here that can help the defense and the prosecution didn't give it, no matter how she thinks it could have helped or hurt the client, she has to give it. And I mean, don't hold all the cards. Like we play this game often. Just give us all the information and see how it is. Like, I don't like when they don't play fair.
Yeah, and of course, defense and prosecution have different burdens, different obligations. This is the obligation of the state so that we are not having malprosecution and having proper cases. Now, we're going to continue live with this Florida case and more legal analysis after this break.